Alrighty, this We the People News. One more time at it, okay? Not attorney, not giving legal advice, okay? Educational purposes only. Never, never, never look just straight forward. Always look around you. Be able to protect yourself by any means necessary, including using the Second Amendment. You got to arm yourself with knowledge, okay? And I'm here to help you out a little bit, allegedly. All right. So apparently, this is a representative out of Wyoming, okay? And she's supposed to be an administrative attorney, which I found interesting in a lot of different directions, right? Since crimes is under commerce, which is under administrative, and all judges are in the capacity of administrative, which is a magistrate, you don't very rarely get to see a judge or judicial branch. All right, they go through the administrative process first, which is handed down to us, I believe it was 1947 Administrative Act, that all attorneys, United States wide, come up with to violate your rights so they can get income from you because you have to call them because you're not smart enough to do it on your own. Just saying, people. This is the way their minds work. But she sounds really good. But let's break some of these things down she's doing. Now, Representative, if you ever see my video and all that, I don't know what your true intention is. So maybe be due to your knowledge of the administrative shit, all right, maybe you're trying to clean this up. Okay? So, I'm just arm length from your words because I don't know what the intent actually is.
I would take your testimony a bit more seriously, Mr. Vladeck, if you actually had ever complained or shown any light on the Biden administration's efforts to forgive the student loans in violation of the law and court order. Ms. Wade,
Now, let's stop there for a second. She automatically put the buck onto the Biden administrative. All right? But both parties, don't let them fool you. Both parties absolutely are operating in this administrative capacity. Okay? Whether they've been attorney and not been attorney and all that kind of stuff, they all been using administrative to violate everybody's rights. Both parties. So the simple fact just being one-sided on this would be incorrect because both parties have been involved in this.
Appreciate your passion for this issue. It is something that is incredibly significant, and I think the caterwauling that you hear on the other side is what happens when you shine a light on the scurry little things that live under most rocks that most of us find rather disgusting.
Again, she said, what on the other side? All right, so let's hear what some of these other things are going on, which is in conflict of what it actually been going on.
24 version of CEI's 10,000 Commandments found that federal regulations, total compliance costs, and economic effects are at least $2.117 trillion annually. U.S. households pay an average of $15,788,000 annually in a hidden tax, which consumes 17% of income and 22% of household expenses.
Oh, by the way, Representative, arm length, right? This is supposed to be volunteering on this tax thing. Just saying, from the people and part of the state. Okay? This is supposed to be volunteering with the threat of arms in your back.
Biden-Harris administration imposed over $1.7 trillion in cumulative regulatory costs on the economy, surpassing all predecessors. The issue of overregulation in this country is absolutely real, and it is people like you that are affected, regardless of whether Mr. Vladeck feels that you should have a voice in these proceedings. Mr.
And she is absolutely correct. It has just taken over everybody's lives.
Smith, I want to turn to you because I think people need to understand what ALJs, administrative law judges, and administrative law courts actually do in this system. If you want to talk about unconstitutionality, Article 3 establishes an independent judiciary to protect citizens from loss of life, liberty, and property without due process of law. Over the last
All right. So she understands that. All right. But the Supreme Court, the Article 3 Supreme Court, is acting under the administrative. There'd be magistrates up there, and they're passing rulings upon administrative and not judicial. They have not been, they've been doing it more here lately, just to clarify, on, but for years, we have not had an Article 3 judge in a very long time. These recent judges, whether they're conservative or not, don't really matter. They've been acting in a more of a Article 3 capacity. Okay.
50 years or so, a variety of federal agencies have created their own court systems led by administrative law judges. It would come as no surprise to no one that agencies enjoy outsized success in proceedings before these ALJs. After all, they're wearing the same jerseys, they're on the same team. In Article 3 courts, as provided by the Constitution, the SEC only wins about 58% of its cases. And between fiscal year 2011 and 2014, the SEC, however, won an average of 90% of its cases in front of ALJs. The FTC, who you went up against, wins not over 90% of its cases before its own ALJs. Yet Lena Khan, who was the head of the FTC under the last administration, lost almost every single case she ever brought before an Article 3 case or an Article 3 court.
And again, why? Because they technically never seen an Article 3 judge. All right. Now, just because it's the Supreme Court or this, that, here, and there, they still work in both capacities. But in order to operate in a Article 3 capacity of a judicial branch has to be common law. Okay? It has to be outside the scope of administrative. So if you're arguing about administrative processes, then it stays in administrative processes. All right? You got to challenge the Constitution of the administrative statutes to see if it's even constitutional. But before then, you got to verify that the courts of these judges, supreme and lower, are operating in a judicial capacity or the administrative magistrate capacity.
Was forced into the FTC Administrative Law Court, or ALC, proceedings. Were you provided with the same protections and rights you would expect in an Article 3 court, such as due process, the right to a trial by jury, that sort of thing?
Absolutely not. It was a foregone conclusion. Frankly, it was described to me by my attorneys as hopeless. There was a 0% chance over the previous 20 years of getting a fair trial. And even though it's...
Sit and think about that. Previous 20 years. Now, I'll go further back even further than that. But even him knowing that the previous 20 years that you wasn't going to get justice because they're not seeing a judicial judge. They're seeing all magistrates.
It came out, if it went to appeal, the appellate process would be only reviewing the FTC's version of events. They get to write the entire record, and you never get a day in court. Maybe you get an appellate review to see if they made an error in the law, but we would never have gotten a chance for an independent arbiter to hear our claims.
I would think.
So even when you do an appeal, right, the judges are going under the magistrate capacity, the administrative branch, under the Commerce Clause. Okay? You're not going to find true justice. You may get remedy, but in order to get remedy, the judge has got to play with your mind. All right? Sometimes you're going to have other people winning, So the courts can look good and say, see, we ruled it was unconstitutional. Okay? But they still did it under the administrative, saying it was unconstitutional, and the person never seen actual judicial judge.
The people on the other side of Mr. Vladek would be concerned about the violation of constitutional rights that you just described, but apparently they're more concerned about protecting the unelected bureaucrats and their ability to send millions of dollars to things that we don't want to pay for, such as trans comic books for people in Peru. The FTC enjoys over 90% success rate in proceedings before the ALJs, as we just talked about. And what I understand is that you were forced to spend $20 million defending yourself in these FTC proceedings, having been an administrative law attorney for many years.
There you go. There lies the problem, right? My problem, right? She knows what's going on in these administrative processes. She should be educated to know, even in the criminal codes, that's administrative process. And that 9 times out of 10, you will not see a judicial judge. Period. So she should know this. Okay? After all, she's probably spent thousands of dollars educating herself. I never went to school and I'm educating myself.
Describe this as the process is the punishment. Would you agree?
The process was a heck of a lot of punishment. However, it was nowhere near what was being threatened. For a $13 million acquisition, the government was basically looking to seize $1 billion worth of intellectual property, as well as half our customers, and an unlimited liability. So the process was terrible, but we had to go through it because the alternative was even worse.
As you likely know, in this Congress, I have introduced the Seventh Amendment Restoration Act, which provides Americans with the right to remove their cases before an ALJ to an Article III district court. Do you think that that is something that would have helped you in pushing back and fighting back against the FTC in these horrific proceedings?
All right. And there again, we lie the problem. The Seventh Amendment is already good. There does not be an extension. These judges and attorneys should already know to put it in the judicial branch. So the sheer thing that she's saying that she wants amendment to 7 may be changing things, but all that judge and attorneys have to do is actually put it in a judicial branch. Okay? You don't need to add an amendment. The Seventh Amendment is just fine the way it is. That's where your due process is. And due process still stands if your attorney and judges actually do the right thing. Okay? And again, if she went in there and she wants to change things, change the 1947 Administrative Act. Okay? Thin that down. Matter of fact, dispose of it. Get rid of it altogether. All right? There's still administrative in there, but it's more clear and more of a straight line and not all these zaggly lines spreading out, violating everybody's rights and everybody's due process. Right? We're getting arrested under not warrants. We're not getting arrested due to all 5 elements of a search warrant. We're getting arrested by information. Well, where's that in the Constitution? Well, it's not. It's under administrative. That's the reason why you don't never get to see a judge. All right. Let me breathe.
I have to say that that proposal is beautiful in its simplicity, and I think it actually would fit what we've all talked about, the system of checks and balances functioning properly, that an American should be able to say, my goodness, if I have the government coming after me, may I please have an independent judge where I can plead my case and have a chance of prevailing.
Thank you, Mr. Smith. Thank you, Ms. Wade. Thank you.
And again, what did he just say? Right? We have it. The judges and the attorneys must follow it. And her being an attorney should already know this. She should not even thought about how to extend or amend the Seventh Amendment because it's good as it stands. We have been thrown into this administrative branch way too often. And even if she adds amendments to all this to give us opportunity, which is already there, it's just your attorney say, no, we're not going to go there. We're going to suck you dry. And we need to fill up the prison complex because they don't have enough revenue.
Dr. McLaughlin, for being willing to come here and expose this horrific situation, this horrific administrative situation that we're dealing with. I yield back.
And again, it's been so corrupt. Is it possible her intent is actually start breaking in and start changing things? Okay, I don't know. I'm not in her state. But that being said, she should know, period. Changing the Seventh Amendment is not going to do a whole lot of good when the administrative out through the country and even to the Supreme Courts of Article 3 judges acting in administrative magistrate capacity. It's not going to change nothing. But you can go in there and get rid of the 1947 Administrative Act and actually start dialing it down and maybe start putting statutes over there